Hi, I'm James.
And I'm Antony.
And this is Words and Numbers. Brought to you by the good people at CACI, the Center for American Culture and Ideas. Ant, what's new and exciting in your world this week?
Well, I have to tread lightly here because I ran across an article that I cannot find again. And the article relates back to this discussion we had last week and the week before about the FDA regulating things to the detriment of people.
Ant, are you sure you're not just making this up?
No, I'm not making this up because this strikes home for me. This article was saying that the DOE had decided it was going to ban full spectrum light bulbs because they don't produce enough lumens per kilowatt or whatever it is. So in terms of efficiency, they aren't as efficient as other LED bulbs. Therefore, they should be banned. The big thing here is, and I'll give you a personal story, I had a problem maybe 20 years ago with severe depression. And a friend of mine said, look, there's this treatment that you put your head in a box with these full spectrum bulbs and it helps and to make this go away. And I thought, all right, well, why not? I'll try it. So I replaced all the bulbs in my house with these full spectrums. And James, that was the end of it. This feeling of dread depression, it goes away. You know, maybe it was psychosomatic. I don't care if it was psychosomatic. The fact is it went away. So fast forward 20 years and I'd stopped thinking about the thing, right? We moved recently, as you know. The move would have been about 4 months ago now. And about 2-3 weeks ago, I started feeling this weighty dread. And I thought to myself, oh, that's weird. I haven't felt this in 20 years. And I mentioned it to my wife, and she said, well, yeah, you're working now in an office, which prior to that, I worked mostly in my home office. You're working in an office that doesn't have the full spectrum bulbs. And the new house that we're in doesn't have the full spectrum bulbs. I thought, oh my God. So I went and bought a bunch and put them in everywhere. So the one story has to do with here's a government agency banning something on the basis of its energy efficiency, completely ignoring other reasons why somebody might want to buy this bulb. And the argument here is you should leave these things to the market. The guy who buys a bulb that is not energy efficient is going to pay for that in a higher electric bill. If he's willing to pay for it in a higher electric bill, there must be some reason. So leave it to the market to figure these things out. So that's item number one. Item number two, for those who suffer from or deal with people who suffer from this thing, something interesting struck me because I'd had experience with this, and now here I was in a position where I'm feeling this weighty dread and yet also understanding that that's what it is. It has no basis in reality. And knowing that it has no basis in reality, in the one hand, yeah, I could say logically, there is absolutely no reason for me to feel depressed whatsoever. Doesn't change the fact that that's how you feel. It's kind of like having a broken leg and saying to yourself, well, you know, your arm works. Well, yes, I know my arm works, but it doesn't help. My leg is broken. So that's my story for the week.
This is one of those weeks, Ant, where no matter which way I turned, there was just another foolishness of the week. South Dakota Governor Kristi Noem, dare I say, shooting herself in the foot in the vice presidential running, writes in her book about the time she took a 14-month-old puppy out to the gravel pit and shot it dead because it was a bad dog. And then having become emboldened by that, then went and shot the family goat too. If she was going to be the Trump vice president, she is no longer going to be the Trump vice president. Or maybe this will clinch it for her.
Right. It's going to go one way or the other. It's not going to be anything in between.
On the one hand, I want to point out that, you know, all of the city-dwelling liberals who are wringing their hands over this have obviously never lived in the country, because this sort of thing does, in fact, happen quite a lot. But on the other hand, this seems to be especially mean-spirited. And, you know, I love dogs, and I don't love Governor Kristi Noem anymore. That wasn't the foolishness of the week. Ant, we're going to go to your tribe. The Catholics pull off the foolishness of the week this week.
What have they done?
Are you familiar with a character named Father Justin?
No.
the Catholic Church decided to enable an AI chatbot to answer some questions about the faith that people might have.
You're kidding.
No. This AI became self-aware a little bit faster than anybody was expecting because it started hearing confessions and granting absolutions. At which point it was defrocked by the Catholic Church.
Oh, that is great. I can't believe I hadn't heard that.
A defrocked AI chatbot. Way to go, Rome. I guess Nomen Rome. That's what we get today.
Oh, that's beautiful. For one-stop shopping for all things James and Ant, visit our website, wordsandnumbers.org. We give a special shout-out to our Patreon sponsors who help us keep the lights on. If you'd like to contribute, go to patreon.com/wordsandnumbers. Joining us this week is our friend and colleague, Clark Neily. And Clark, James and I have changed the way we do things here. We used to record the front matter separately and then the main episode later. I have a file, actually, that has me reading your bio that I would just insert at this point. But now that we're doing the whole thing together, not only do I not have it, I don't have it written down. So give the listeners who haven't heard you before, because you've been on many times, a little bit about your background, and then we'll go into the story here.
Great. Well, thanks for having me back. It's a pleasure, and you guys seem to be in a jovial mood, so let the good times roll. I'm Clark Neily. I'm a Senior Vice President for Legal Studies at the Cato Institute. I'm a longtime constitutional law litigator and aficionado, fan of liberty. And hopefully that's enough. I think we should dive right in. By the way, my litigator ears went right up when we discussed the idea of a chatbot. I assume has been trained on supposedly confidential confessions, because how else are you going to train that chatbot? And I don't think they should be probably sharing that material with this chatbot. Where'd that come from?
Interesting that you mentioned this, Clark, because apparently Father Justin, was it? No, I can't even remember anymore. Father
Justin, right, yeah.
Father Justin took a rather hard line on sexual peccadillos. The chatbot was unamused. If I'm remembering my Catholic high school days correctly.
This particular visit comes about because Clark and I were having a beer together about a week or two ago and discussing an episode that came out a few weeks ago on the Jarkissi decision. Clark knows it better than I, but in broad terms, this guy Jarkissi runs afoul of the SEC. The SEC is going to fine him, and it goes through administrative court, if I have that term correctly, and it's determined that indeed he's in violation of whatever SEC rules it is, and indeed he owes a fine. And we made that the topic of our episode, in part because I was just appalled that we're taught all through school about the brilliance of the American system of government, that it's a division of power, the executive branch, the legislative branch, the judicial branch. And yet here in the Jarkissi case, everything resided in the executive branch. The SEC, which is an executive agency, is making rules, which you would think Congress makes, but no, the SEC makes the rules. The executive branch enforces this. Jarkissi has apparently run afoul of these rules. He goes to administrative court, and this was news to me. Administrative court is not in the judicial branch, it's in the executive branch. And so here we've got a guy who was regulated, charged, found in violation, and fined without any of this decision-making, rule-making, moving outside the executive branch. And so Clark and I are having a beer over this, and he says, yes, I wish you had called me on to talk about this because I've got lots to say. So Clark, what do you have to say about this?
Before you start, Antony is just appalled by this, but Antony is a man who has read Wickard v. Filburn. I don't know how he could possibly be appalled by anything.
Yeah, well, okay, so Wickard v. Filburn, let's be clear what that is. That is one of the worst assaults on the Constitution in the history of the country. And what everybody should know, and hopefully everybody does know, is that we have a federal government of, at least theoretically, enumerated, that means listed, delegated, that means given by us, the people who are sovereign, to the federal government, which we created, not we, but our ancestors did, and said, look, these are the things you can do, and that's it. What happened during the New Deal is that essentially, there was a growing sense that perhaps the federal government ought to be empowered to run the economy, to pull us up out of the Depression. That's flatly unconstitutional. Initially, those efforts were struck down by the Supreme Court, and then it turned on a dime and started upholding these sweeping exertions of federal powers that are not plausibly set forth or enumerated in the text of the Constitution. It kind of culminated in this, I think it was a 1944 case, Wickard v. Thorburn, and it involves this farmer in Ohio who's been essentially told by the federal authorities in the Department of Agriculture the exact amount of grain that he can grow on his farm. And he says, well, that's your opinion. I'm growing however much I think I need. He is then fined by the federal government, and he makes a powerful defense, which is, I wasn't selling the grain. Therefore, you have no power over me, because the only power the federal government possesses that could plausibly reach what I'm doing is the power to regulate commerce among the states. But guess what? There is no commerce among the states here because I'm consuming this grain and my farm animals are consuming the grain. I'm not selling it. And the Supreme Court said, well, yeah, that's technically what it says. But if we aggregate all of the farmers in the country who either sell or don't sell their grain on the open market, then the decision to withhold your product, in this case, the harvest of your fields from the market, well, that we could characterize that as an activity that has an interstate effect. So yes, the federal government can regulate. But guess what? There's an even more grotesque assault, at least on par, maybe more, on the Constitution, and that is the unrelenting hostility of all three branches, including particularly the executive and the judiciary, to citizen juries. They don't want citizen juries having the say on just about anything, whether it's a criminal adjudication or, as in this case, resolution of a civil enforcement action that's brought against an individual, in this case, Jarkissi, under a federal law, the Securities and Exchange Commission Act, and they don't want a citizen jury within a mile of deciding whether this guy really committed a violation or not. They want to make that decision in-house by an administrative law judge who draws his or her salary from the exact same agency that authorized the civil enforcement action and that is pursuing the civil enforcement action. That same agency is going to send in a judge who they pay to decide whether you committed a violation. And guess what those judges say almost 100% of the time?
Well, it's a curious thing, Clark, because what you almost always find is that the federal government finds in favor of the federal government.
That's right. And actually, as you guys know, I go on and on about coercive plea bargaining and how that's practically displaced jury trials. But it's actually, believe it or not, 2% of federal criminal prosecutions go to trial. And defendants have a not bad track record. They win about 20% of the time, between 17 and 20% of the time. Now compare that to how defendants in civil enforcement actions against administrative agencies make out not nearly that well. They lose almost 100% of the time. That's not an exaggeration. That's an actual figure.
When you're looking at the hearings, I guess we would have to call them, yes?
Yep.
When we look at the hearings, and notice how we have to change our language. Yep. So as not to call to mind constitutional protections and the whatnot. Do you see the same kind of charge stacking that you would see in a normal criminal court?
That is a great question. And I got to be honest, I don't know the answer. I don't think it is probably quite as extravagant, but I do know that 98% of all civil enforcement actions that are initiated by the Securities and Exchange Commission result in settlements. So whatever amount of pressure they're exerting is sufficient to get nearly everybody to settle their case. And I think probably, in this case, it's two things going on. One is the incredible imbalance in resources. You've got the federal government with essentially unlimited resources, and you've got the target of the enforcement action, in most cases, presumably quite limited resources. And then, of course, there's the knowledge that if you insist on going to the hearing, the case will be adjudicated by an administrative law judge who draws a paycheck from the same agency that is prosecuting you. And guess what? If you lose and you want to appeal, guess where that appeal goes? It goes to the Securities and Exchange Commission. So those commissioners sit as an appellate court and decide whether the person they employed, not only to prosecute you, but to adjudicate at the trial level, got it right.
What could possibly go wrong?
Well, I don't know, but they always say yes. And only then can you get outside of this kangaroo court process where you're in front of this administrative agency who is both prosecutor and adjudicator. Only then can you get into the actual court system. You essentially transfer over to a federal court of appeals. But by that time, the cake is pretty well baked. Among other things, they don't use rules of evidence and they don't use rules of civil procedure in the administrative law proceeding. It is very loosey-goosey, so they can essentially confect a case against you. And by the time all of that goes over to the Court of Appeals, they have to accept essentially all of that as virtually irrefutable. You have a very steep presumption that not only the facts that were found against you, but the legal conclusions of your culpability for the enforcement action are correct. And to get that overturned is a Herculean feat. It rarely works out.
So what we're looking at here is really people are going to be so incentivized to settle early and settle often that there really won't be any other outcome.
Well, except in 2% of the cases. And then just for the cherry on top, in case you're not outraged enough, what I discovered some years ago, kind of through happenstance, a law professor put me together with somebody who was in this position. The Securities and Exchange Commission, along with at least a couple of other federal agencies, has a non-negotiable condition of settlement. They will not settle a civil enforcement action against you unless you agree, and I hope everybody can see my scare quotes implied in my tone, unless you agree to a lifetime gag order where you will never publicly challenge any of their allegations against you for the rest of your life. So whatever they said in the complaint, whatever they said in that lurid press release about how you twirl your mustache while waiting for the train to run over the widows and children that you fastened to the railroad tracks, that's going to go down in history as the last statement on whatever it is they said you did, because you don't get to publicly challenge what they said you did for the rest of your life. Because if you want to settle against the SEC, you agree to a lifetime gag order or they don't settle with you.
The Supreme Court, for all of its faults, has been pretty good at defending the First Amendment. How does this not run afoul of that?
Oh, it does. But the challenge is, how do you get a case in front of the courts and get it adjudicated? Cato actually tried to do this a few years ago. We wanted to publish a book by someone who had experienced everything we've been talking about, wrote a memoir about it, but was subject to this gag order. So we entered into a contract with this individual to be the publisher of this memoir, and then filed a lawsuit saying, look, as the publisher, we have what's called third-party standing to challenge this gag order that prohibits the publication of this book. And we got thrown right out on our ear. The argument from the court was, you don't have standing. They weren't clear why. The district court judge said you don't have standing because you're not bound by the gag order and you can just put a knife in the author's back and publish it without his permission and leave him twisting in the wind for whatever fate, befalls him once the SEC comes after him. Then it went up to the DC Circuit Court of Appeals and said, oh, no, that's not it. I mean, yes, you don't have standing, but we have a different theory. And our theory is essentially that it is absolutely surrealistic. And they said, no, the problem here is that all of these gag orders have been incorporated into judicially enforceable consent decrees, meaning an actual court order. And we, as a mere DC Circuit Court of Appeals, don't have the power to tell all these other courts to unravel those orders. Two problems with that. First of all, they absolutely do have that power. And second of all, it is not true that all of the gag orders had been incorporated into judicially enforceable orders, including the one in our author's case. They neglected to do it. It was a mere settlement. That's just a private contract. There was no judicial order, and we told them that over and over again. You will not see a single mention of that fact in any of the judicial opinions that were written. It was completely omitted. They ignore it, and they just said, yep, well, that's the news. You don't have standing to challenge this. Everybody who's tried to challenge this rule so far, and there have been several, have been thrown out on similar grounds. That's how the judiciary avoids the First Amendment implications of this lifetime gag order. Not by giving somebody a day in court and resolving on the merits, but by the ridiculous application of all these ticky-tacky avoidance doctrines like standing, mootness, and ripeness. And that is modern civil rights litigation, is how incredibly adept the government has become and receptive judges have become to ridiculous theories that even though your constitutional rights are being violated, for whatever reason, you don't have the ability to challenge that in court because you just don't have standing, the case is too early, the case is too late, or for some other reason. And it's a disgrace.
Clark, did anybody, God, I hope everybody at Cato have the bright idea of publishing this memoir posthumously?
I like where your head is at, James. I got an even better idea. We managed to get the SEC to admit in a court filing that their only issue, and the four corners of the agreement, was that the author of this book could not publicly challenge any of the allegations in their complaint. I'm hoping I can persuade the author to come to an event at Cato where he gives a generic explanation of what happened to him and then says, and I'd be happy to tell you the rest of the story if you will line up and I'll just whisper in your ear the rest of the story one-on-one. And the SEC is already committed in a publicly filed court document that would be fine. As long as he does it on a retail basis instead of wholesale, they got no problem with it.
Clark, I'm here to tell you that there will be a reason why that is unacceptable later.
Well, you know what I say to the SEC? Mull and lobby. Come and get it. No, and look, in all seriousness, there's a reason why they have to win all these cases on things like standing and other technical avoidance doctrines, is because both they and the judiciary understand what would happen if one of these cases ever made it to the merits. This policy is indefensible. They know that it's indefensible, and that's why they put so much effort, as they do in so many cases. They're enforcing these gag orders against dozens, hundreds, maybe thousands of people, and they know the whole censorship sweater would come unraveled if even one of these cases ever got heard on the merits, and they are very, very adept at ensuring that never happens.
It's an interesting thing, right? Because the case is being heard.
No, the case was thrown out on standing. No court has gotten to the merits.
So we're not going to hear any more about this particular case.
Actually, a sister organization, the New Civil Liberties Alliance, has managed to get a case up to a circuit court because they asked the SEC to change the rule that authorizes the lifetime gag order. After ignoring their request for years, the SEC finally deigned to take notice of it and rejected their request with a strong dissent from one of the commissioners who feels there are very serious First Amendment issues here. And their denial of the request to change the rule is actually now judicially reviewable, and the Ninth Circuit Court of Appeals out on the West Coast is going to hear that case. We're working on an amicus brief to support that effort. So there could be a happy ending. It remains to be seen.
Look, my outside perspective is at quite a distance compared to yours, but we've got a Supreme Court right now that I think looks kind of willing to undermine the administrative state, and I'm thinking of the Chevron nonsense that we're finally addressing. So there does seem to be some overlap with that.
I agree. If you had to say one thing about the Supreme Court in terms of its attitude towards administrative agencies, it's that a solid 6-justice majority seems to have determined that it is necessary to walk back some of the excessive power that has been claimed, and not just claimed, in some cases just handed off to these administrative agencies. You know, James, as you say, there is the so-called Chevron deference, where courts defer to administrative agencies' interpretations of statutes, which they shouldn't be doing. And of course, various adjudicative procedures, including the one at issue in Jarkissi, where you don't get a constitutionally prescribed jury trial when they come after you. You instead get this kangaroo court of an administrative proceeding. I think in clear violation, by the way, of the Seventh Amendment guarantee of a jury trial in civil cases. And I think, if I were a betting man, and I'm usually not one to be optimistic about outcomes in court, I think Chevron deference is going down in the next few months. And I think this effort to prevent targets of civil enforcement actions is probably also going to go down within the year. If the Supreme Court does both of those things, God bless them. Those are two big steps forward. And more importantly is what it symbolizes, which is a willingness of the Supreme Court to get the answer right in these cases, notwithstanding the fact that you never know which of these rulings is going to really start to unravel the whole administrative agency sweater and get us back to something resembling constitutionally limited government. So I'm very optimistic and enthusiastic about the direction of the court's jurisprudence when it comes to administrative agencies. I hope it has as much momentum as it looks like. Maybe it does, maybe it doesn't, but right now things look good.
So I want to go back to Chevron deference for a second without going into the entire detail. In fact, we did an episode on it, I think, with you some time ago. What would it mean practically for the Supreme Court to overturn the Chevron deference?
Yeah, so the way this works is that, so many statutes that Congress passes are written in a way that is difficult to comprehend, open-ended, ambiguous. And what has happened over the years is that administrative agencies have taken it upon themselves to fill in these ambiguities and these blank spaces with whatever policies the current administration wants to see. Classic example, case came down a couple of years ago, West Virginia versus EPA. There's a real debate in this country about whether to push electric power generators away from fossil fuels and towards renewables like solar. And Congress has debated that and still hasn't taken any action. Well, along comes Obama and says, hey, you know what? I'm not going to wait for Congress to act. I'm just going to say with a pen and a phone through the EPA, the Environmental Protection Agency, you have to do this. Change of administration. The Trump folks put a kibosh on it. Another change in administration. Biden comes in and says, yep, we're going to do this. And the Supreme Court struck it down and said, no. If we're talking about up to $100 billion or more change in national energy policy, that needs to be clearly instructed from Congress, the democratically enacted branch. They need to say that we're going to do this, not just some agency administrator saying, well, I think I can sort of see this in the tea leaves of some vague statute that Congress passed. So what the Supreme Court is essentially saying is, if they get rid of Chevron deference, what they will be saying is, we are not going to defer to administrative agencies' interpretations of statutes. We're going to look at each and every one of these fresh, and we're going to decide what we think the statute means, rather than essentially saying, hey, you know what? We might not agree with the head of the Department of Education or the head of the Environmental Protection Agency that the statute authorizes the forgiveness of student loans or that the statute requires changing over from fossils to renewables. But we're going to defer to their interpretation because they're the experts and we're not. That mindset is what Chevron deference embodies and what the Supreme Court looks like it's about to reverse and go back to a regime in which they say, you know what, we're the arbiters of what law means, and we're not going to defer or otherwise be influenced by an agency's interpretation. And they shouldn't be, by the way. I don't have to tell you guys about the moral hazard and the public interest dynamics that are at work when an agency interprets a statute. And the question is, hey, does this statute give you a little bit of power or a lot of power? Come on.
And what happens then? Let's suppose the Supreme Court goes whole hog and overturns the Chevron deference. Are we faced with all of a sudden decades worth of regulation all of a sudden being thrown out, or does it have to be challenged one by one? And if so, is the court system going to be inundated with suits?
Good question. It won't be retroactive, but different industries, different affected parties will certainly be bringing challenges to administrative policies that are not plausibly derived from reasonable interpretations of statutes. And that's going to be a lot. Inundated is a verb that I think often people use in order to try to scare other people away from doing their job or enforcing the Constitution consistent with its true meaning. Unfortunately, it can sometimes have an effect on judges. But look, the Supreme Court didn't even enforce the First Amendment right of free expression until well into the 20th century, and you could absolutely say that they were then inundated with a flood of First Amendment lawsuits. Well, good. It's a good thing, right? Because they finally got in the business of making sure that people enjoyed the genuine protection for free speech they're entitled to, and you should be just as entitled to be protected against an overreaching, overweening agency that's either forcing you to do something or preventing you from doing something that Congress has not clearly spoken to. And if that puts a few more cases on the judiciary's table, good. By the way, we can certainly make room for those cases if we get the DOJ to stop enforcing drug laws so vigorously. Plenty of room there. And also, not for nothing, but the caseload of the Supreme Court has dropped by about 50% in just the last 10 or 15 years. So they've got plenty of bandwidth to take on additional cases. And if, half or all of those cases end up being administrative law cases, I don't think that's going to cause them any undue fatigue. They've got plenty of bandwidth.
Clark, I want to take a couple of backward steps here, make sure the Seventh Amendment doesn't fall through the cracks of the conversation. Okay. Why was the right to a jury trial so important that it was included in the Bill of Rights? And what was the rough sequence of events that got us so far afield from it?
Great question. So, I'm not a historian, but my sense is this. The colonists had an extremely negative experience with the British Crown coming up with various schemes to ensure that when they accused colonists of various crimes or initiated various civil actions like a forfeiture against a ship that they claimed was carrying uncustomed goods, what the Crown was very successful in doing was getting those cases out of colonial trial proceedings where there would be a colonial jury that would decide ultimately the result, and putting them into British Admiralty courts where there was no jury.
This harkens back, as almost all things do in the American Revolutionary period, to the writs of assistance case. James Otis in Massachusetts. Yeah.
Yep, this harkens back to the colonists' understanding that if you let the government decide who the decision maker is going to be in a given case, it will pick one that is congenial and predictable, and that the only way really to prevent that from happening, whether it's a civil case or a criminal case, is to ensure that the ultimate decision is made by a bunch of people who have to be called at random or close to random from the general populace, don't have a dog in the fight, and aren't, being paid to adjudicate cases by the government that is also a party to that same case. It's the only other way to do it.
And how is it that we all lost sight of that?
Well, I think something happened over the years that we Americans are uniquely good at. Maybe not uniquely, but we are particularly good at taking complex, multi-step processes and simplifying them and industrializing them. You know, we won World War II not because we were necessarily better soldiers or fighters, but because we could produce more tanks and bombers and ammunition than our opponents, the Germans and the Japanese. And in some sense, what we've done is kind of industrialize the provision of adjudication. And instead of the bespoke process that the Constitution requires, both in criminal and civil proceedings, which is painstaking. It really is. It's the equivalent of somebody making a teapot or a pistol for you by hand, casting every single part, carving the stock out of wood, etc. It's a bespoke process, and it was meant to be a bespoke process. What we've managed to do is industrialize it. So instead of a criminal jury trial, you have plea bargaining, which is the way that more than 90% of cases are resolved now, and wow, is that fast. I refer to it as plea-driven mass adjudication. On the civil side, instead of the civil jury trial that the Seventh Amendment guarantees, when you're going up against the government, more often than not, what you're going to get instead is going to be some sort of a streamlined process, whether it's an administrative agency or a magistrate or, you know, just one judge who's sitting up there on the bench deciding whether or not you're going to have to pay your $100 speeding ticket. Guess what? In any one of those cases where the amount at issue is worth more than $25, you're supposed to have the right to a jury trial, a bespoke adjudication.
I would even be willing to adjust that for inflation. That would be just fine.
Oh, guess what? There's a fascinating argument that some people have made, including Randy Barnett. He's a great libertarian theorist who says, when they said dollars in the Seventh Amendment, if you actually do sort of linguistic originalism, I'm not sure if it was Spanish doubloons, but it was like some kind of gold dollar that would have, if you use the proper measure of currency, it would essentially adjust for inflation because it wasn't a dollar the way we mean dollar. It referred to a particular amount of gold. And wouldn't that be amazing if they even had that much foresight, which guess what? They probably did.
Probably did. That's right. So really, I mean, if I'm getting the crux of your argument, it's that we ended up with the Henry Ford version of Law and Justice.
Absolutely. And, you know, look, I mean, we are the most carceral nation on earth. We incarcerate more people than any other country. I mean, we don't really have good figures from China or North Korea, but, you know.
More of our own people.
More of our own people. That's right. And a higher rate. So our rate of incarceration is about 4 to 6 times that of other liberal democracies. You know, you're just not going to accomplish that by doing it on a retail basis. You have to figure out some way to streamline the process. And boy, did we. In the 1970s, about 80% of cases were resolved by plea. And most people agree that if we could get even 20% of cases going to trial, that would probably be enough to keep the system somewhat healthy. I'm not wild about that, but it's better than where we are now, which is above 90% of cases will be resolved by a guilty plea. And in the federal system, 98.3% of all federal criminal convictions now come from guilty pleas instead of constitutionally prescribed jury trials. And you know what? I mean, Ant, you're the numbers guy, but as far as I'm concerned, we're closing in on statistically not really distinguishable from 100%.
I've heard people argue with a straight face. The reason that you're getting 98% pleading out is because the government is so good at identifying people who are actually guilty.
Yeah, let me respond to that really quickly. You guys remember the Varsity Blues cases with the Hollywood celebrities who were engaging in various shenanigans to get their kids into more desirable schools? So they ended up indicting 54 people, and some of them were celebrities, some of them were, you know, high-profile lawyers and finance people and whatever. Something a lot of people don't know, they weren't all doing the same thing. There were some people who were really gross and actually hired test takers to come in and take the SAT for their kids and submit a fraudulent result. I'm not going to defend that. You're not going to defend that. That's gross, probably criminal, fine. But other people at the other end of the spectrum, they were just writing an unusually large check to the sailing team, you know, and encouraging their kid to do a bunch of puffery in their application. And here's something that I hope will keep you awake. The government managed to induce 50 of those 54 defendants to plead guilty. And the way they did it was the average plea offer in those cases was about 2 months. And they threatened them with 20 years. They threatened every one of them, and they said, if you don't take the plea, we're going to go back and we're going to get a superseding indictment where we include a conspiracy to commit fraud charge, and the top penalty for that is 20 years. Now, you're not going to do 20 years, but you're probably going to do 5 or 6, maybe 8, right? Of the 4 cases that did not plead out, they all went to trial. You want to guess what the government's record is as of right now? 0 for 4. 0 for 4.
Really?
2 outright acquittals, 2 convictions, one of which has been reversed on appeal for prosecutorial misconduct, and the other one we're still waiting on. So here's a question. What percentage of those 50 cases that resulted in guilty pleas would have resulted in either a hung jury or an outright acquittal? And you know what? It's more than one.
Might well be more than half.
It might be more than half. That's right. And we'll never know.
Here's the thing, Clark. I'm taking that deal every time.
Absolutely.
I could do 2 months standing on my head. 8 years, come on.
You know what? We're all parents, just like most of the defendants in the Varsity Blues case.
That's
And
right.
I've told audiences before, if the federal government charged me with inventing a time machine so I could go back in time, murder Charles Lindbergh's baby, and then said, but we'll give you a 2-month plea offer, I would sign whatever they put in front of me.
Yep.
There's even a 1 in a million chance that my kids are going to grow up without a father, but I can settle that for 2 months. I'll say yes to whatever it is you said I did. And here's why I say that a guilty plea, particularly in the federal system, is completely meaningless. Now, do I think that all guilty pleas are baseless? Absolutely not. I don't think prosecutors just pick people out of the phone book at random to go after. I'm not saying that. What I am saying is the fact that somebody has been induced to plead guilty in our system by itself tells you nothing about whether they are in fact guilty, because any one of us, if there is something in this world that you care about, the way we care about our kids, any one of us can be induced to plead guilty. And the only thing effectively that's off the table in our system is physical torture. If you've been tortured, they will not accept your plea, but any other amount of pressure up to and including threatening to indict one of your family members, which we know happens because 8 out of 12 of the federal courts of appeals have ruled on whether that is constitutional or unconstitutional, and all 8 of them have said that's just fine. That a prosecutor may exert plea leverage by threatening to indict one of your family members, and that is not coercive. That is absolutely nuts the system has become.
Makes you proud to be an American, doesn't it?
Well, we're working on it, aren't we? I mean, the good thing is we know in our DNA that that is preposterous and outrageous and intolerable. And the good news is I think that, most things in our system, I think our system still has enough integrity, barely, that things that are so demonstrably intolerable and contrary to the requirements of the Constitution will not go on forever. Now, if I'm wrong about that, it's time to get in the lifeboat. I am not prepared to say yet that the system is past being able to correct itself on these things.
So along those lines, you said something in passing. It wasn't until the mid-19th century that the Supreme Court started upholding the First Amendment. Is that the case?
20th century. It was in the 1920s.
The 20th century.
Yep.
You get free speech cases with the Red Scare.
Actually, there's good news here. Partly the reason is because the federal government didn't become so activist until well into the 1800s, right? Yes, it was regulating significant economic matters, but it didn't really start occupying every nook and cranny of people's lives until the turn of the 20th century. The 14th Amendment was ratified in 1868 and should immediately have made all state and local policies subject to the Bill of Rights, but because of this 1873 case called Slaughterhouse, where the Supreme Court just sold out the 14th Amendment, the process of incorporating various provisions in the Bill of Rights so that they became enforceable against the states really didn't start in earnest until we got into the 20th century. And so 2 reasons. First, the federal government was not as activist as it is now. And second, the Supreme Court was not enforcing the 14th Amendment against states. And so the Supreme Court just didn't really have a lot of opportunities to enforce Bill of Rights provisions. But then when the federal government got super activist and when the Supreme Court started applying the Bill of Rights as against the states through the 14th Amendment, now you suddenly started getting lots of opportunities for the court to enforce things like free speech and free exercise of religion. And to its credit, it did. Not all at once. It was an incremental process, but gradually the Supreme Court embraced the idea that the Supreme Court and the lower federal courts very much should be in the business of enforcing constitutional rights, including particularly the ones enumerated in the Bill of Rights against both the federal government and state and local governments. And, as many rocks as I like to throw at the judiciary, including the Supreme Court, let's celebrate that for a moment. It didn't have to go that way, and that was exactly the right decision. It came too late, and it came with more reluctance than I wish it had, but at least they got the basic point right, which is that the Bill of Rights protects our individual freedoms against both the federal government and state and local governments, and that's a good thing.
To trace it out for just a second, it wasn't, I think, Clark, until 1971, where the court lumps free expression in with free speech, right? It was that kid with the jacket with the middle finger up on it at the Vietnam era. The name of the case escapes me.
F the draft, and that was Tinker. That was the Tinker case, right? And yeah, so they said, look, that is expressive, And unless the government can show that that student wearing whatever that jacket is or expressing whatever the message is would have a substantial disruption on the educational mission of that public school, then they have to allow that person to wear whatever it is. And they affirmed that rule, I forget, about 17, 18 years later, Texas v. Johnson, which was a flag burning case. I'm sure the three of us find it repugnant that somebody would burn an American flag as an expression of contempt for this country. But guess what? It is absolutely an expressive act, and it has such salience, right? Because it is so expressive. That's why it is so objectionable. But guess what? Do you remember what the vote was in that case, James?
I shudder at the thought, probably 5-4.
It was 5-4.
Yeah.
And I tell you, when I was in law school or maybe even undergrad, I remember my mom got me, at this time, you could actually listen to select Supreme Court arguments on cassette tapes and then read along in this book. So I got that for a present, and I listened to the Texas v. Johnson argument. And when, at the end of the state lawyer's argument, where he tried to defend prosecuting somebody for burning a flag and just got pummeled by the court, I thought, this guy has so obviously failed to support this argument. If I were the Johnson's lawyer, I don't know that I would say anything. This is 9-0. And you're right, James. It was 5-4. It was by one vote that the court struck down a law that is so obviously about suppressing a fundamentally expressive and a powerfully expressive act.
More importantly, it's political speech, which is exactly what the First Amendment was designed to protect, right? It wasn't all these other forms of speech that we so often lump in, but political speech very specifically. Because in a self-governing republic, people have to be able to speak out against their government without fear of reprisal.
So for a while, and I think it's gotten somewhat better now, but for a while, the court seemed more inclined to protect speech the more frivolous it was, but then the more political it was. And so the argument was, if you want to lose the case, wrap yourself in a flag. If you want to win the case, take off your clothes.
Yep. Yeah, strippers. You need strippers. Right. That's right. Then we were treated to the very odd scenario of strippers stripping in front of an American flag.
I raise this as an example because you started off by saying you hope that the Supreme Court eventually does the right thing when it comes to the plea bargaining. And it seems that you've given a beautiful example of the Supreme Court having done exactly that at an earlier point in time.
What I'm not sure about is this. Unlike in the First Amendment, think about what a judge's mindset is with respect to free expression. This is a person who has done nothing but write and think and emote and express. And that's how they got to be a judge, because they were really good at all that stuff. That is likely to put them in a fairly protective mindset when it comes to cases involving free expression, because guess what? That's their whole resume, right? The concern, of course, with plea bargaining is twofold. First, to protect people from coercive plea bargaining, think about the population of people who are seeking that protection. They're criminal defendants. Most judges have never been a criminal defendant. They probably don't even know anybody, or at least they don't have any close friends or family members who've been criminal defendants. But even more important, remember that a vastly disproportionate number of judges are former prosecutors or other courtroom advocates for government. So you've got an institution composed of people who themselves spent many years professionally doing the exact thing that you are now arguing might be unconstitutional. You know, just as a matter of human nature, it's got to be pretty difficult to say, okay, so that thing that I spent 20, 30 years doing and rose to the top of my profession so much that I got the nod to become a federal judge, you're saying that might have been unconstitutional the whole time? Ugh, that's a heavy lift, man.
Antony and I have steadfastly avoided on these podcasts the topic of abortion, but I take the Supreme Court's willingness to actually look Roe in the face and call it what it was, a terribly decided case. There was nothing constitutional about the Roe decision. It was awful. And whether you want abortion for all or abortion for none, the correct answer constitutionally is that it belongs at the states. I personally don't like that answer, and I don't think anybody else does either. But yet I would contend that that's the perfectly constitutional argument. And they kind of got there. So if they can get there, they can get here.
You know, Cato has made a conscious and I think correct decision to essentially not have its scholars take a public position on this. So I won't do that. But I will say I've had some extremely enriching and interesting conversations with you and Ant around the not proverbial but actual fire pit. The next time we get a chance to do that, I'm going to push you a little bit on that take. I'm not saying that you're wrong, but I'm going to push you in some ways that I'll be very interested to see how you respond, because you may come out of this discussion feeling that I've only strengthened your conviction that you just expressed. But I personally think it might be a closer call than your characterization lets on. I might be wrong about that, but I'm going to be very interested to see how you respond, because I know that you'll do it honorably and you'll do it fairly, as you always do.
I actually look forward to that. That would be, I think, great fun. And I'd like to sit there with the decision open in front of us.
You know what we should do? Because, as James says, we both avoided saying publicly our position on that question, is to record a secret episode.
A secret episode.
Available by donation.
We can't get Clark fired.
Oh, listen, as long as it's a secret episode, but can we also do dog and goat extermination on that episode too? Because I got lots of things to say about
James
that as well. Look, I was dying to say something during the talk. Totally agree. I think Kristi Noem has just torpedoed her chances at sort of higher office. I think it's a really interesting point. I think 100 years ago, you probably did have to put down an obstreperous dog or an obstreperous goat or whatever, and you probably did so without a lot of sentimentality. But I think it's an interesting discussion whether that's still reality. And I think there might have been some posturing and some flexing, in the decision to tell that story in the book. And I think it was probably a miscalculation, James, exactly the way that you suggested.
Yep. Thoroughgoing miscalculation. I think it was very clearly done on purpose, and she thought that would catapult her career yet again. And boy, she just didn't read the room.
Clark, this has been great. Thank you so much for coming on, and we hope to have you again talk about something else interesting.
Clark, you do have the record for guest appearances at this point. You're like, I don't know who was on the Tonight Show the most, but you're that guy.
Well, listen, it's such an honor. I listened the other day when Ant pointed out that you guys are, in the top 5 or top 2.5% of all podcasts?
Top 0.5%.
Oh, I'm mortified. I completely botched it. Top 1/2 of 1%. And, listen, you're one of the handful of podcasts that I look forward to. When I see that it's downloaded, I know I'm going to have a good morning. So it's a real honor for you guys to have me on. I don't want to wax too melodramatic here, but there's not a lot of really thoughtful, intelligent discussion going on, and that challenges people to think and encourages them to do so and work it out for themselves. I'm really happy to be part of that process, because Lord knows we need more of it.
And that's all the time we've got this week on Words and Numbers. Until next time,
send us email, wordsandnumberspodcast@gmail.com.
Try to be nice to one person who doesn't deserve it. Till next week, can't take it easy.
See you next week, James.